What do you do if your tenant is not paying rent? So many of the videos that you've been watching relate to the eviction of tenants from a property once they fail to pay rent and you terminate the lease agreement. But what about the actual collection of the rental due? Now, the first thing that I need to start off with is this myth that you have to grant the tenant a grace period. Please remember the grace period is already provided for within the CPA. So that first letter of demand that you sent off has a built-in grace period of 20 working days. Please do not wait 7 days as an example before sending out that first notice, because then you're giving them far more days than is needed. And remember, even if you're a tenant and you're watching this, 20 business days is quite a long period of time. So please understand that if you do not pay rent when you're supposed to pay rent and the bond goes off and the landlord now doesn't have money to pay the bond, that notice needs to go out, because if it comes out later or the following month that the rent can't be paid again, some landlords may actually go bankrupt. Some banks have foreclosed on houses for failure of tenants paying rent. So I understand tenant rights, I understand landlord rights, and I keep saying that there has to be a fine balance. But tenants also need to understand it's not personal if that legal notice goes out, because that 20 business days is quite a long period. And because it's a long period, if it takes too long to go out, it goes into the following month. And if it goes into the following month, unfortunately, there might be another bond default. And we cannot afford, especially nowadays, to have too many bond defaults, because the banks do take action. And unfortunately, that action costs. It comes with a legal cost, which unfortunately the landowner or landlord will have to pay the bank. So if we can all work together to avoid something like this from happening, that would be the ideal scenario. And so this leads me into the next part of the conversation, which is, what is the first step then? Well, the first step is that legal notice. That legal notice is the grace period. It's just contained in a formal legal notice because the Consumer Protection Act expects that all landlords provide tenants with this. So there was a time, for example, where the notice periods were a lot less. And landlords would allow a certain period, a 5-day grace period, to allow a tenant to make payment. And after that, send out a notice demanding payment within 7 days. Now, because these have all been incorporated in the Consumer Protection Act, this is no longer needed. So that first notice is simply to say, we noticed that yesterday you did not pay the rent. We notice that now you are in arrears. So please take notice that if you do not pay up what is due, the lease will be terminated. So it's not that it is terminated, it will be terminated, right? It gives a certain period of time and allows the tenant the opportunity to make payment within that period of time. If the tenant makes payment during that period of time, then the breach is remedied and the lease continues as per normal. If the tenant fails to make payment within that period of time, the next notice goes out. Now, please understand, this isn't bureaucracy, it's not red tape, it's simple logic. You're first granting a period of time and threatening a cancellation. After that is done, you actually effect the cancellation with another notice saying, it doesn't appear that you've paid, we are hereby cancelling the lease, please move out the property. And so this is another myth. It's regarding this notice to vacate, eviction notice, eviction letter. I've heard many, many names being given to the same letter. So this is a letter. It's not a court order. It's simply a demand that the tenant now vacate the property. Why? Because you are hereby cancelling the lease. So in order to proceed to court at a later stage if needed, you have to properly terminate the lease. You can only do that if you've given 20 business days notice. If now the 20 business days has lapsed, you're informing the tenant that the lease is terminated, but in that same letter, you're demanding that the tenant vacate the property. So it's the same letter. So there's only 2 letters or notices that really go out at this stage before taking official legal steps. It's asking the tenant to remedy and telling the tenant that because he hasn't remedied, It is now cancelled. He needs to leave the property, right? And that notice to leave the property doesn't actually have to grant long periods of time. The lease is terminated. In theory, under our law, the tenant has to leave the property immediately because there is no lease over that property. And again, from a notice perspective, the tenant has been aware for approximately 1 month now, 20 working days, that he has failed to pay, and this will result in a cancellation and will result in him being asked to leave the property. So again, that notice, that period within which the tenant has to find alternative accommodation has already begun to run. So this is just something to bear in mind. All these periods come together and try and afford as much opportunity as possible to afford tenants the rights to find alternative accommodation. Now, please don't get me wrong. I understand that certain circumstances with tenants differ, and there are exceptions, dire exceptions, but I also understand that with landlords, there's also dire circumstances. So one has to look at the law and the wording of the law and why it exists in a very particular way. Now, moving on from this, the next part of the conversation is if the tenant does not vacate the property, if the tenant does not pay the arrear rental. Now, my videos have already dealt with evictions, so I don't want to repeat myself on the legal phases of evictions. There's many videos on this channel that relate to that. Specifically regarding the rental, this is a separate process to the eviction process. So please understand that simply because you've approached an attorney now and you've asked the attorney to institute the eviction application, this does not mean that the rent will be collected. All the ins and outs of the eviction application, the costs and the time frames have to be considered also, because it's not instant. And again, that's why I implore you to please watch the other videos regarding evictions, because this will give you greater insight into the eviction process. The rental collection, though, is a completely different action. It's a different process that goes through the court. It's drafted differently, looks different. It's under a different case number, usually for the sake of pragmatism. So the way that this looks like is an action goes out. It calls upon the tenant to pay a certain amount, and that you're approaching the court to ask for an order that that amount be paid, right? This refers to the arrear amount. In addition to this, you normally ask that a further amount be paid for the amount of time that the tenant remains on the property. Please note, this is not rent. Why is this not rent? Because rent is a contractual consideration for the occupation of a property. The tenant under these circumstances isn't actually entitled to occupy the property. So what you're actually asking for here is not rent as much as it is damages. It just happens to be the same amount because the damages are calculated as the rent you could have received had you placed a different tenant on the property. But the nature of this amount has now changed from rent to damages. This is also very important because you do not want to fall into a trap where you almost renew a tenant's occupancy by accepting what is called rent that entitles the tenant to remain on the property. So be very careful. There is a distinction between rent and arrear rent and damages. In the summons, you will be asking for both, and your attorney should understand how to draft this because it is two different claims. You then approach the court, you institute the action, you serve it on the tenant. Now, this is where you have to be very careful. The promise of rental collection is something that, in my opinion and at my firm, we cannot and will never promise. Rental collection is infamously difficult. Why? Remember that most tenants would actually rather pay rent. And this is why sometimes having conversations with the tenants is very important, because send out those notices, but you might realize that a tenant is not being malicious, not intentionally trying to avoid paying. It simply cannot, right? And this is where you negotiate with the tenant so the tenant moves out as soon as possible so that you can place another tenant on the property, but that you also have empathy and afford this tenant the opportunity to find another place. And it goes without saying, negotiations work 100%. So these circumstances that I'm discussing relate more to situations or scenarios where unfortunately a negotiation or a conversation could not be had for one reason or another. Now, the collection of rent is very difficult because if the tenant's not paying you, there's a very good chance that the tenant simply cannot afford to pay you. So you rushing in there and trying and throwing money at the problem, trying to get judgments and execute the judgments may simply result in you throwing good money after bad money. So at our firm, what we normally suggest is issue the summons, demand the rent, and approach the court. If the tenant doesn't oppose or defend, which typically is the case, you get default judgment. If they do defend, you'd get summary judgment. So get a judgment, right? Now, if it's a default judgment, this normally gets listed against the tenant's profile, right? Rightfully so. The tenant owed money. The tenant didn't pay the money. You're now informing the credit bureaus that the tenant didn't pay money, so he's been in default. So other people that are going to give this tenant money or any relationship the tenant gets into, they need to be aware that there has been a scenario where the tenant has defaulted. That's the point of these listing requirements. Now, with these listing requirements, what happens is at a certain point in time, if the tenant does come right and realizes that he has to pay you, he will approach you and he will pay his debt. But just in case the tenant doesn't approach you, it is listed, meaning that if he ever tries to obtain credit elsewhere, he will now realize that there is still a judgment against him and that he has to satisfy that judgment before he will actually be given credit. So this is one very long-term solution to collecting rent. It's not running in there with a sheriff paying costs, because you can go after furniture, you can go after whatever you need to go, salaries, but more often than not, you find that there is nothing to go after. So all you're simply doing is putting yourself in the queue and waiting. So there is a solution. We normally suggest that at a minimum, simply because there's a chance, small, but there's a chance that in future, at some point in time, you will collect rent. From time to time, what we sometimes do advise, especially with larger amounts, is that maybe you attend a property, you do a search, you see if this former tenant has found employment or where they're staying, so that you can reassess the situation. If you find that they have found their feet, you can always approach them, negotiate with them, and try settle the debt. But it is completely up to you on whether you simply stop at default judgment or take further steps after that. But again, there should never be a promise that the debt will be collected.